Good afternoon, everyone. Thank you for joining us live today. And we're going to talk about pitfalls that you want to avoid when going through a custody battle. I am Conti Smith. I practice family law here in Central Florida. And you also have the privilege of hearing from one of our superstar associate attorneys, Amina Turner.
Hi, everybody. Again, my name is Amina Turner. I also practice in Central Florida family law.
All right. Well, thank you for joining us. I know you're busy, and I appreciate you taking time to educate some of our viewers. And so we're going to, like I said earlier, talk about certain pitfalls that we see time after time when we're litigating custody battles. So, Amina, in your opinion, what's one of the major pitfalls that you always see when people are litigating in family law cases, and specifically in custody cases, or time sharing, as we call it here in Florida?
Well, it's got to be social media. It's got to be the posting on social media, the Facebook check-ins, where you are going out, even the messages between the parties, right? So the inbox, right? The instant messages or the DMs, right? That people communicate on social media. Those documents are admissible and they come into play and they become a part of the litigation in these custody disputes. So specifically, we're talking about cases that involve children, and people are literally posting their every move, right? So when they're going out, hanging out with friends, and they're traveling, going, down to Miami on South Beach, there's a lot of videos, right? Recordings, and they don't have to be long, right? But if your face is there, we can see that it's you. And sometimes these are instances where children are involved, or they're on the video, or their postings of the children, right? So
let's give some examples, right, about how your social media can, really impact your case. We've had, cases where, the one parent didn't get the kids because they said they had to work, but they posted videos of them, out at the club or out doing something that wasn't what they said. Or they weren't where they said they were. There's another reason why they didn't want to get the kids, and it wasn't because of work. If you are saying that you are making minimum wage and working, 20 hours a week, it's not really going to make sense if you're posting wads of cash on Facebook, right?
Definitely.
People, and it's amazing because we always see these things like, why did you post that on Facebook, right? And if you're going through litigation, you want to make sure, that, your page is private. You don't want to destroy any evidence. You don't want to do that, but at least make sure your page is private. It is amazing to me how many people who are in a very contentious litigation or battle regarding custody, or we call it time sharing in Florida, but or child support, and they just do not think to ever go back and just look at what the public can see on their social media accounts.
Oversharing. They're oversharing. It's like people don't need to know that much information, especially while you're engaged in litigation. So you were talking about instances where people are claiming to be unemployed, but there's pictures of them. We've all seen the pictures like this where there's wads of cash where people are posing, but people are claiming to be, earning not that much money, but people do things on the side, right? So we're in this age where people a lot of time have multiple sources of income, right? They may sell things on the side, or they may offer services to the community on the side, and sometimes they're generating income from it, and social media can be a very good tool in being able to provide some evidence to that effect.
Right. And so we offer free consultations. So if you are in the Central Florida area and you want a free consultation about your particular issue, feel free to give us a call at 407-831-0203. Now, I wanted to make this point. It's not only, in custody battles that you want to be careful about what you put on social media. Even when kids aren't involved, right? So if you're asking for alimony and you're saying that you have a need, right? That you have a need and you need some support, from your spouse upon the divorce or even during the divorce. But every other weekend, you're in LA, New York, Chicago. We look at that. So as attorneys, when we're preparing for a case, we run, background checks. We look at your social media, your Facebook, your Instagram. And so, when you're saying, oh, I don't have any money, whatever else, if your attorney is doing their job like we do, we're going to say, okay, well, so how do you explain to me how you went on a Disney cruise back?
We like to scroll. Yes, right, we do.
Explain to me how you went on a Disney cruise back, in December of, 2019. Explain to me how you were able to afford this, that, or whatever else you're posting on there. So again, whenever you're in any sort of litigation, or even when you're interviewing for a job, you want to be mindful about what you have on social media. And, people, if you're talking bad about the other parent, that can be used against you, even if you're not saying it on your Facebook page itself. But if you're messaging somebody that knows the other parent, they could give that message or those messages to the other parent, and that could be used against you as what we call an admission by party opponent at trial. So,
we've done that.
Right. So texting people, anything you put in writing, you really want to be careful about, how you say it and what you say, because that can be used against you. So
even the comments on social media, right? So not even just the postings, but what you comment, right, on other people's posts or your own post, right? Referencing either the parties or the kids or anything involving something that could impact child support or alimony or anything involving your case.
And so
be very careful.
Right. And so also when we're having cases when one parent is alleging that the other parent is using drugs or, drinking alcohol excessively, we look at Facebook to see, are you posting about those things? Are you posting about you going out every weekend? We look at those things to help bolster our argument. So again, especially when you're litigating a case, you do not need to post everything on social media because it can come back to haunt you. So you want to be mindful about that. Another pitfall that you want to avoid when you are going through a custody, or as we call it in Florida, a time-sharing battle, is be gracious. Don't seem like the unreasonable parent, especially in your written communications to the other parent. Most times, 9 times out of 10, the communications between the parties are going to come into evidence, and you have to act like the judge is going to review every message you write. Okay. Mm-hmm. And so if you've drafted something and sent it that was crazy a few months ago, you need to show improvement in your communications, right? Before you get to trial. So it's amazing what people will say when they're upset, but you always want to communicate as if a third party is going to review your correspondence and make a decision about you based on that. Understand that the judge only has a limited amount of time to be exposed to you, right? To get a flavor for who you are. You may have a half day trial, which is 4 hours. You may have a full day, which is 7 to 8 hours. You may have a multiple days of trial, but that snapshot, right, is going to really be what the judge is going to look at. Your communications, how you're acting or how you acted prior to the case, being filed and, before the trial. So the biggest pitfall is that people just say whatever they want to say, not thinking or not knowing that, later on they're going to be judged based on how they communicated and what they said in their communications. If the child is born out of wedlock, the mother is the default custodian of the child until there's an order that states otherwise. So a major pitfall that I see are mothers that are, it's my baby, you can't see the baby, you can't do this, or you can't do that. We literally had one mom basically say to our client, until the court orders that you have, time sharing, you won't get any. And let me tell you something, that did not go over well for her when the judge was able to read how many times she said, let the court tell you when you can see your kid. Let the court tell you, and it really did not work out well for that particular mother. It represented the father at that point. And literally what we did is we went through all the text messages and literally said, okay, she's told him 20 times that he cannot see the kids until the court gets involved. So, Your Honor, this is why we're here. We're here because she refuses to co-parent, right? She refuses to co-parent until you order that she has to. And one of the factors that the courts look at is if the parent that has the children is allowing access to the other parent that doesn't have the children as much. And that's a major factor that the courts consider when determining time sharing. So, if even though the law states that the mother is a default custodian until there's a court order that states otherwise, you do not want to be the mother going into court where you're saying, you can't see the child, it's up to me, you have no rights, whatever else, because that's going to catch up to you, when you get to trial or when the judge is able to assess what all you've said, and they can see that you're not really allowing access to the other parent. So
most definitely.
Yeah. So yes, that's what the law says, but the courts will consider whether or not the parent is being reasonable with allowing access. And that's a really big factor that a lot of people, seem to fall into that pitfall of, oh, well, I have rights, you don't. So guess what? It's all what I say. It's when we're the lawyers on that side, it's hard. It's a hard argument to make, to justify.
It's like, don't make our job more difficult than it has to be, right? Right. So another pitfall that I see, and we see in a lot of these cases, is, when relationships end and either parents are either going through a divorce or they've separated for whatever reason, a lot of times their personal feelings and their emotions about the relationship ending has a huge impact on the decisions that they made for the child and whether or not the kid should go to the other parent or not, or like that falls into what you're talking about and being unreasonable and not being the parent, that's going to be looked at as restricting the other parent from the child, right? You don't want to be on that end. And so as difficult as things may be, as parties are going through these difficult times, we would oftentimes encourage, our clients to kind of take the personal away from it a little bit, kind of step back, try to look at things objectively. It's a difficult moment, but you really want to just think about what's best for the child, what's in the best interest of the child. How is the child going to be helped from this situation or hurt from this situation, right? So that's the primary focus.
And another pitfall that we see often is, well, I haven't received any child support, so he can't see the child.
Oh, yeah.
No. Child support and allowing time sharing are two different issues. So even if you are not receiving your child support, even if it's court order, you're not receiving it, that is not a basis to restrict time sharing with the other parent.
Not to say that you don't have relief, because you can file appropriate motions to seek relief regarding the child support issue, right? So like Conti said, if it's court ordered, you can file a motion for contempt, right? Or if it hasn't been established, then you can file certain motions or petitions in order to get it established. But by all no means do you say, because I'm not receiving support, the other parent doesn't get to see the kid. That's not appropriate.
Right. And that's you do not want to do that. Now, another pitfall that we see is that people or a parent that's paying child support and them getting frustrated because they don't know where the money's going, and them saying things about how the child support money is spent. And so in time sharing cases, which is what, like I said, people frequently call this custody, right? But in Florida, it's time sharing. When we are having, time sharing issues or whatever else, you really can't, or child support, you really cannot, dictate how the money is spent, right? That's not really up to you. So if you're sending messages like, well, tell me how you're spending the money. Well, what did you do with the child support money? The court's not going to require the other parent to tell you what they did with the child support money. Mm-hmm. So you want to make sure that you're avoiding seeming ridiculous or controlling by trying to mandate that someone tell you how they spent the child support money, because the courts are not going to require the parent receiving the child support to tell you how each dime was spent.
Oh, here's another one. Don't pay in cash, right? So you even though we're in the age of technology and all of these applications exist and methods to send money very conveniently exist, we still have cases where parties will come to us and tell us, I provided financial support for my child. I supported her. Well, how did you pay her? Well, I paid in cash.
That's ooh.
Yeah, it's a big it's a very big blow when you're talking about a situation where you're talking about retroactive support for maybe 3 or 4 years, right? And you're saying that you made cash payments and you don't have any proof or any evidence of it. That's a very big pitfall. That's a very big pitfall. So if you're paying support to a party, whether it's court ordered or not, right, you want to make sure that you're sending the money in a way that's documented. Bank deposits, Cash App, Venmo, Zelle. There's lots of options out there available for you to be able to provide payments in a way that's documented.
And not just cash. We've had clients that have sent money via money orders, but they don't have the receipt of the money order. So I mean, really, you want to document it to where you have a paper trail that if you lose it, you can still go back and find it. In Florida, we can go back 2 years to assess back child support. So it's important that even if, even before litigation starts in your case, or even when you're on good terms with the other parent, that you keep track of what you've done financially for the child. And if you're not good keeping paperwork, you have to try to maintain those records electronically. So like you said, Zelle, Cash App, all that. Or even you can even pay the child care provider, the daycare directly. They're going to have records of what you paid. So you need to figure out what you're good at, what you're not so good at, and just make sure that you have a method of payment that you're going to be able to retrieve if you need it. If there's ever a question about what you paid for and what you didn't pay for, because what you'll see a lot of times is that, there's a child support you'll start a child support proceeding, and then the arrears will be assessed at something $10,000, $20,000. You're like, whoa, that's crazy. I help pay for this and that. But if you don't have the proof, there's not much that we can really do with that. So if you're not married to the other parent, if there's ever a chance that you will go to court, you need to make sure you're keeping documentation regarding what you're doing for the child.
Even if you think there's a chance you'll end up in court, still keep documentation. You can be on the best terms with the mother or the father of your child, but if you're doing something for the benefit of that child, you want to make sure you have records, whether you guys are on good terms or not, because oftentimes what we see is that when parents are on good terms, instead of documenting things, sometimes mom will call up and say, hey, the baby needs diapers and wipes and formula and things of that nature. And then dad will go and drop some cash off, right? Well, there's no record of that payment. There's no documentation of what he bought or what he purchased or how he provided for that child. So even if you say, no, I won't end up in court. That's not for me. I don't need that. Yes, you do.
And 9 times out of 10, when we get to court, the other parents say they didn't receive the money. They didn't receive it. So the court has this he said, she said situation going on, and we're trying to figure out, well, how do we address this? So again, Cash App is your friend. I feel like in 2021, there are plenty of ways for you to give money to somebody that you can have a paper trail regarding what you gave them. So please utilize all of those different avenues to make sure that you create a paper trail. Again, you guys, this is Conti and Amina, my superstar associate attorney here at the firm. One of them, we have 2 amazing associate attorneys. Please, if you have any questions, you can either send us a direct message. You can drop your questions in the comments. You can call us for a free consultation. We offer 15-minute free consultations. You can call us at 407-831-0203. Make sure you follow us on YouTube, on Facebook, Instagram, TikTok, LinkedIn at Conti More Law. Please follow us and make sure you share information with anyone who may need help with the family law issue. Thank you for taking the time to join us. If you have any questions, reach out to us. We want to be a resource to you and our community. And remember, stress less, choose more.